will get started. So hi, everyone, I'm Kevin Organiciak. Hope you're doing well. Thank you for joining us today. I founded the Association of Test Preparation, Admissions, and Private Tutoring about a decade ago, and we're sort of fierce proponents of independent education, independent educational consulting, owner-operator run tutoring businesses, and basically, the high quality, accessible programs that live in communities and in regions around the country. Before starting TPAPT, I worked for Kaplan, and I worked there for about 10 years. I ran one of their larger P&Ls at a territory level. And in 2005, I co-created the industry's first higher score guarantee. So that's sort of my big claim to fame in the world of commercial test prep and tutoring. And we're really pleased to be providing this free knowledge to all the independent programs out there in the country. And I'm happy to welcome Peter G. Goodman, an employment law specialist. And he's here to join us and talk to us today about the basics of human resources for independent tutoring, test prep, and educational service firms in general. And I will let Peter talk a little bit about his background. And just so you know, I'm going to be running our presentation from my end. If you have questions during the presentation, please put them in the chat. And then once Peter finishes, we'll go through and I'll read the questions, and we'll hopefully answer everything we can in about an hour. So with that said, Peter, I'm going to let you take over.
Okay, thank you, Kevin. Welcome, everybody. Thank you for having me today. I appreciate the opportunity. Just so you understand what I'm looking at now is I'm looking at Kevin. At some point, I will have the slide deck in front of me, so I cannot see any of you. So it's I'm actually giving this presentation to a slide deck essentially. But in any event, oh, there's somebody. There's Neil. Hi, Neil. So, all right, getting on with it. My name is Peter Goodman, as Kevin said. I'm an attorney. I'm located in New York City, and I practice primarily in the area of employment law. My client base is primarily small and medium-sized businesses. My range of services is from everything from hiring and disciplinary issues, terminations. I do a lot of litigation, so I represent clients in court and in arbitrations and mediations with respect to various employment-related claims, such as discrimination and retaliation. And I also represent clients in connection with or in front of state and federal local agencies. And often those issues do involve independent contractor and / employee classification. So I've had some experience in this area, and I'm happy to share my knowledge with you. What I'd like to do today is go through essentially the basics of this issue and of this dilemma, if you will, at times for employers. I'm going to, just as I said, I'm in New York City, so the law varies around the country. It varies between federal and state jurisdictions. So, given the time constraints we had, it really is not practical for me to go through a survey of the law of all the various jurisdictions that are represented by the people who are attending today. So what I'm going to do is give more of a general overview, and I will, however, reference in large part New York law. So keep that in mind, that the reason I'm doing that is because that's where I'm located. I also practice in New Jersey, but I'm principally in New York, so I'm going to be using New York as a frame of reference. The law is not significantly different from jurisdiction to jurisdiction, but there are differences. And if you have an issue, then you should definitely consider the local local law and regulations that are applicable. Now, Kevin, I'm unable to see the slides. So is there something that that I need to do on my end? The only thing I have is, looks like the toolbar of the computer.
Can everyone see understanding classification of independent contractors? Huh.
No.
I will try screen sharing it again here.
Okay, I see it.
There we
No?
go.
That's weird. It said it was sharing it before, so sorry about that.
No problem. Okay, and also just so all of you understand, I don't, Kevin's controlling that screen, so I'm going to have to ask him. I'm going to be saying the name Kevin quite often, because every time I need him to switch to the next screen, that's what I'm going to say. So, so Kevin, please, second screen. Okay, so the agenda, these are the areas that I want to cover. So initially, let's talk about recent trends and enforcement developments in this area. Secondly, risks of misclassification. So as business owners and operators, what do you have at risk if you classify someone as, it's typically where the mistake is made, is you classify them as an independent contractor where they should have been an employee. So we'll talk about some of those risks. What are some of the red flags and triggers, some of the incidents and the events that could give rise to scrutiny or you know, a lawsuit or an audit with respect to an independent contractor misclassification? Then we'll talk about the characteristics of a true independent contractor, an independent contractor which is really beyond dispute. And then the next segment, I think you'll find the most relevant to your businesses, because in New York, at least, there is a body of case law that deals with tutoring companies and teaching businesses, and whether the tutors and teachers that they engage are independent contractors or employees. And I'll go through many of the factors that the courts have looked at in connection specifically with those businesses. And then last, I'll speak very briefly about independent contractor agreements and some of the important provisions that you might want to include in those agreements, as well as how those agreements might assist in finding an independent contractor classification is correct. Okay, next slide, please. So on recent trends, what we see a lot is there are people who apply for unemployment benefits when their work is discontinued. And that's where I've seen in my practice a tremendous amount of activity in connection with the classification issue. And I've also seen it not just personally, but in some of the cases that have come down that I've been reading in the gig economy. So, you know, I'm sure you're all aware, obviously, of Uber and Lyft and DoorDash and those types of companies, which have come under scrutiny for a number of reasons, including, you know, whether they are treating their workers properly. They treat them as independent contractors, and that's been challenged. And in fact, that's been challenged by individuals who have stopped working for those companies for various reasons and have applied for unemployment benefits. And that is where the issue of classification has been litigated very often. Also, what we see in terms of trends is that you know, some employers pay their employees as independent contractors during a probationary period and then shift them to a payroll, or employers don't understand the distinctions between independent contractors and regular workers and get themselves into some trouble. Kevin, next slide, please. So on the enforcement side, let's go back. Here we go. Right. On the enforcement side, enforcement developments, there has been a lot of activity over not just recent, year or years, but going back probably close to 10 years. There's been quite a bit of enforcement activity from the government. New York and California.
Can everyone please mute themselves? Terrific. Thank you so much.
So, so in New York and California, I read a study recently. New York and California have lost billions in unreported wages and associated payroll taxes. And that really is one of the principal drivers of government intervention. So as a result, you see various task forces that have been created both on the federal and the state level. On the federal side, the US Department of Labor and the IRS have entered into a memorandum of understanding where they cooperate and collaborate with one another regarding misclassification. There have been 29 states by the last count that I've seen that have interagency task forces relating to misclassification. And if I can just share with you a case that I had a few years ago that was kind of swept up, certainly from my client's perspective, by one of these task forces. It was quite an unfortunate incident. My client actually got involved with there was an anti-retaliation unit of the New York State Department of Labor's, the department that investigates misclassification. So essentially, you're not permitted, at least in New York, to retaliate against someone who complains about how they're being classified as an independent contractor or employee. And in this instance, my client was planning to terminate this person. It was his only contractor / employee. And he was going through some very significant financial trouble. So he was planning to terminate this person anyway and find a replacement for far less money. And it so happened that that morning, the person came in and said, well, listen, I was talking to my accountant, and my accountant thinks that I should be paid as an employee and not paid as an independent contractor. And the response was, well, listen, I think we really should part ways anyway, because I'm really having some trouble with, keeping afloat here. What happened was the person ended up going to the Department of Labor, which conducted an investigation, assessed my client with thousands of dollars in damages and back pay, damages and penalties and interest. And then I got involved after the fact and was able to negotiate a much lesser amount that my client had to pay. But nevertheless, he was stuck paying some significant dollars, and that was just by getting caught in the web of this anti-retaliation unit of the classification of the part of the Department of Labor that investigates misclassification. So they can be aggressive is the lesson there. They can be very aggressive, and in New York, again, it's the Department of Labor, it's the Workers' Compensation Board, and other agencies that all cooperate. So if one agency picks up an issue of misclassification, very often what happens is they will then refer it to the other agency. And then there's, so the potential exposure is compounded even further. Okay, next slide, please. So
Peter?
Someone as an independent contractor, and you fail to pay, fail to withhold taxes or remit taxes to the taxing authorities, and then that person is then deemed to be an employee, well, there's a liability for failure to withhold those taxes, as well as related penalties and interest. Related is bullet number 3, which is the unemployment insurance and workers' compensation premiums. Same concept. An employer is required to pay into those funds, and if you don't, and you're later determined to have been an employer of an employee or employees, there are penalties that are associated with that. And I could tell you also from experience that the workers' compensation penalties are onerous. They're very severe. It's a very difficult board to work with. If you finally do get through to somebody, there is it's an uphill battle to try to get them to reduce some of those penalties. And then there's also potential criminal prosecutions in an egregious case. I saw a question about what is the definition. Well, I'm going to get to that. This is background. I'm going to be digging into the nitty gritty of what an employee versus an independent contractor is. So just bear with me, please. So the other thing I wanted to identify as a potential risk, though, is unpaid wages and overtime. Now, I don't know the extent to which you are all familiar with the FLSA, which stands for the Fair Labor Standards Act. And then there are also state wage and hour laws. In a nutshell, the Fair Labor Standards Act and those state laws require that an employee be paid at least minimum wage for every hour that is worked, and for every overtime hour that is worked, they be paid at least 1.5 times the wage. This has been a very ripe area for litigation. There are law firms that specialize in this. So the issue is if your contractor is actually deemed to be an employee, then there's potential liability under the FLSA and state wage and hour liability. Okay, next slide, please. And then finally, in terms of risks of misclassification, you've got anti-discrimination statutes. Typically, they do not apply to independent contractors. So I've listed a handful of the federal statutes. That's Title VII of the '64 Civil Rights Act, which protects against discrimination in employment with respect to protected classes, race, sex, religion, national origin, et cetera. And then you have the ADA, the ADEA, Age Discrimination in Employment Act, the Americans with Disability Act. So those do not apply to independent contractors, but if you have a plaintiff who's taken the position that they are actually an employee, even though you think they're an independent contractor, there could be potential liability. I mean, that would be an issue that would have to be decided in those cases. There's certain exceptions where those laws do apply to independent contractors. In New York, we have a few. Human rights law in both New York State and New York City, as well as the New Jersey law against discrimination. But it's very costly litigation. Okay, pardon me 1 second. Sorry about that. Had some outside noise, background noise. Okay. Next slide, please, Kevin. Okay, so some red flags and triggers that might lead to a lawsuit, might lead to an audit or some other inquiry or scrutiny about classification. Someone's formerly an employee, now all of a sudden they're an independent contractor. Or you have two individuals or two sets of workers. One set you treat as employees, and one set you treat as independent contractors, but they're doing the same thing. So how do you explain that? Restrictions on independent contractors to work for other businesses. So I'm going to talk a little bit more about this, but essentially, it's inconsistent. Those are restrictive covenants, and you're telling an independent contractor or an employee, look, you may not work for my competitor. Now, there's a whole body of law that deals with restrictive covenants, but without getting into that, the basic idea, though, is that if somebody's an independent contractor, you would expect that they would be able to work for whomever they want to work. So to impose a restrictive covenant, restricting their ability to work for other businesses as an independent contractor, it's really kind of inconsistent with that model. Excessive issuance of 1099s. I have a client who underwent an audit a couple of years ago, and the trigger, the red flag / trigger for the audit was the issuance of close to 500 1099s. Now, it so happened that in that particular business, it was appropriate. These people were independent contractors. We passed the audit without a finding that they were employees. And I'll speak a little bit later about some of the factors that were helpful, but that was certainly the trigger that brought the Department of Labor, that caused the Department of Labor to haul my client in for an audit. Next one, please. So triggers again. We see this a lot. This, and I've alluded to this in my earlier slides, where you have a contractor who's let go and sues or applies for unemployment benefits. That's a sure trigger, because as a business owner, your response is going to be, well, this person's an independent contractor. I'm not liable to them for employee type claims. But then they take the position that, no, I'm an employee, I'm not an independent contractor. And so what you're left with is an issue that needs to be litigated. And as I mentioned, there are law firms who specialize in representing individuals in wage and hour claims. And they're happy to take these cases on and make the argument and develop the evidence that, in fact, this is an employee and not an independent contractor. And then, of course, you have your audits. Okay, Kevin, next one, please.
Oh.
Okay, so characteristics of true independent contractors. And this might start to help the person who asked the question about the definition. So, a true independent contractor is someone who's self-employed in an independently established trade or occupation or profession. They're very often incorporated. I know that in the information technology area, where you have a lot of consultants who work as independent contractors, very often the businesses or institutions, for instance, a hospital or other type of institution, nonprofits, they require their independent contractors to be incorporated. So, it's not always that way, but it's common. They offer their services to the general public. They're paid with a 1099, not a W-2, typically paid by the job or by the hour, but most importantly, they're free from the employer's control. And let's turn to the next slide. They set or negotiate their own rate of pay. They could be paid more than employees. It's not critical, but going to this notion of being free from the employer's control, they set their own schedule. The employer's not controlling the way that they do the job. It's just, this is the job and get it done. I mean, that's not to say there can't be, criteria or guidelines for the job, but they are free to do it the way they see fit. And they're not under the employer's control. And also they can refuse to work. If they're given an offer to provide services, they can refuse them. And then last is, and I found this to be very important, and in fact, in that case I mentioned with the 500 or so 1099s, some of the best indicia for whether an independent contractor is operating his or her own business is whether they have their own business cards, website, stationery. The particular auditor that I was working with on that case, she was so interested in seeing the invoices that those contractors had supplied to my client after they had provided their services. And I went through quite a few of them. I mean, there were hundreds of them, and I supplied them to the auditor. And when she saw that the contractors had their own EIN, they had their own websites, they had their own address, there was very little she needed to know. I see a question pop up. What if they have all of those characteristics? Well, we'll talk. Give me a couple more minutes, but I can tell you that it's a very fact specific. Someone else has the same question. It's a very fact specific inquiry. And if you have all of these characteristics, then I think you have a pretty strong case. That's the way I would answer that question. But the cases that we see which are litigated, you tend not to see all of these criteria. You see the weaker cases, which makes sense. The weaker cases are the ones that get that get challenged. So let's turn to the next one. Just a few more. We have increased business deductions, as I'm sure you're all aware. I mean, that's the reason why people want, or it's one of the reasons why people want to be treated as an independent contractor. They get more deductions. And we talked about the lack of protection of employment, labor, tax withholding, no benefits, and the contractor has to pay their own self-employment taxes. So next slide, please, Kevin. Okay, so now to get into the heart of what one of the questions was. So how do you define it? There is no universal definition. That's a problem because different agencies utilize different tests. You have the United States Department of Labor. You have the IRS, which apply different tests. You have, at least again in New York, you've got the Division of Unemployment Benefits of the DOL, and you've got the Wage and Hour Division of the DOL, and you've got the Workers' Compensation Board. And they all apply slightly different tests, but there is enough commonality that to provide useful and meaningful guidelines. So let's talk about that. Go on to the next one. The common theme is supervision, direction, and control. That's what we see. And so let me just give you some quotes, a couple of quotes from certain cases. Again, these are New York cases. The standard for determining eligibility for unemployment insurance. And again, a lot of the cases come out of the unemployment or unemployment application realm. So what the courts have said is that there's an employer-employee relationship where there is evidence that the purported employer exercised control over the results produced or the means used to achieve those results, with the latter being more important. Well, that's great. It's a fairly general statement. What does it mean in the real world? And that's really where the rubber meets the road. And we can talk about some of that starting with the next slide.
Yeah, to contextualize that, Peter. So if I'm a tutoring company and I train people how I want, a curriculum delivered, or if I hand them a curriculum for use with students, right then I'm exerting control, right? In either of those two cases, am I not?
You are exerting control, and that's going to go into the column favoring an employee classification.
Right.
So it's a good time for that question, because that's the next the next couple of slides, that's exactly where I was going, and I've got that exact factor in one of the slides in those lists. So for tutoring services, there has been a number of there's been a lot of case law which has found an employment relationship between the businesses and providing the tutors and the tutors. And the court has been applying the following principle, where an organization which screens the services of the professionals, pays them at a set rate, and then offers their services to clients, exercises sufficient control to create an employment relationship. Okay, that's a little bit better, a little bit more specific than the last, but still there's a bit of generality there. And as a result, it's a highly fact-intensive inquiry. So let's look at some of the factors. And what I've done here is I've distilled the facts, the factors that have been used and considered by the courts in this group of cases involving tutoring services. And I've pulled them out of the cases. So instead of discussing each case separately, I just pulled them all out, and I thought it'd be more useful to you to see them all in one place. So let's talk about screening. In some of the cases, the courts mentioned that the business interviewed the potential tutors, whether it was an interview by phone or in person. I mean, right these days it would likely be a remote interview, but it's an interview nevertheless. There was a review of the resume and the qualifications. There was reference checks. There were verification of certifications. So if you have teaching certifications or other related certifications, the business would verify those. And there are also criminal background checks or fingerprint checks. So all of those types of activities, according to the courts, have constituted screening for purposes of the tests that I laid out in the earlier slide. Okay, the next 2 or 3 slides, I've set out a number of factors that I've pulled from the cases. And 1 or 2 are the ones that Kevin mentioned before. So to what extent is there a role in matching the tutor and the student? Or to what extent is the tutor permitted to find a substitute or reject assignments? If the tutor is not permitted to reject assignments or to find a substitute, that would be indicia of control and supervision. That would lead to the conclusion of there being an employment relationship. Similarly, you've got timesheet requirements or reporting requirements. Same thing. To the extent that the businesses or the agency is going to be requiring timesheets, reporting, or other types of feedback, or other types of accountability, that is going to fall into the column of an employment relationship. Payment. This is an interesting one. So if the payment is made to the tutor before the business receives payment from the client, the courts have identified that as another factor. And, it kind of makes sense. I mean, then it sort of leads one to conclude, well, this person is really just an employee. They're getting paid whether or not my business, or whether or not the business that engaged me is being paid by its client. I'm still getting paid, just as if you're an employee for any business. Walmart comes to my mind. You work for Walmart, you're going to get paid whether or not Walmart received payment from credit card companies or whomever it gets paid from. Responses to complaints and comments and the ability to remove the tutor. This is a strong indicators about an employment relationship. If the business is the one who is responding to any comments or input from either the student or the student's family, let's say, And if the business has the ability to remove the tutor, again, that is very much favors the finding of an employment relationship, because it shows control. Remember, supervision, direction, and control. Those are the touchstones. Next factors, these are important. Reimbursement of expenses or the supply of equipment, instructional materials, or books. To the extent that the business is going to pay for the expenses of the tutor or supply materials or equipment, books, that is also going to favor some type of supervision, direction, or control over the relationship. In the same way, location of services. There was one case where the court discussed the fact that the services were provided at the business's facility. If there's a physical facility that the business operates and makes available for the services to be provided, that's a strong indication of an employment relationship. And I talked about this before, the restriction on working for other tutor companies or soliciting clients or students. The working for tutoring companies is really I think the more significant restriction. Just to review, if a tutor is restricted from working for a competitor, it really sort of is very inconsistent with it and undercuts the argument that this is an independent contractor. How independent can you be if you're not permitted to work for whomever you want? So, and a similar thing in soliciting clients or students, although it's not as quite compelling. This is the issue that Kevin raised, perhaps through one of the questions that was asked about dictating lessons, observing the tutoring sessions, overseeing the instruction. That's all supervision, direction, and control. And that is going to likely lead to a conclusion that there's an employment relationship. Similarly, student and tutor records, if they're maintained by the business, why? If you're an independent contractor, why wouldn't you maintain the student records and your own records? And then the last that I have on the slide is how tutors are held out to the public. And I put this in here because there was an interesting case I read. There was a decision where the court observed that, this business held out to the public that these are my teachers. These are our teachers. This is the business's teachers. These are our students. These are our teachers. It was very much, the language that he used and the way it held those tutors out was very much, akin to an employment relationship. And there are a few that I didn't put in here, but very quickly, is the tutor advertising? Does a tutor maintain their own liability insurance? I don't know if that's common in your industry, but in some industries it is. So if you maintain your own liability insurance and you advertise, then those would definitely militate in favor of an independent contractor relationship. And then last, on absences, do you need permission? Does a tutor need permission if he or she is going to be absent? So those are, that's a distillation of the many factors that come into play, and it's not an exhaustive list, but this is just taken from a handful of cases. So as you can see, it's very fact intensive. You may have some, but not others of these factors. Now, at least according to the standard of review that was applied by this court in New York, when it reviews the determination of the Unemployment Compensation Board, it's a substantial evidence standard. So if there's substantial evidence to support its finding, then the court is going to affirm it. So there could be substantial evidence going the other way. But if they go one way and there's substantial evidence to support the conclusion of either independent contractor or an employee, then the court is going to affirm it. So it's not arithmetic. You know, it's qualitative more than quantitative. So that should give you a pretty good flavor of what you're dealing with. The last topic is independent contractor agreements. And yeah, I just want to say a couple of things about this, which is that, you know, independent contractor agreements are helpful if you want to establish that an independent contractor relationship exists, but they're not dispositive. So you might have one and the parties might agree between themselves that it's an independent contractor relationship, but that doesn't necessarily mean you're going to prevail if all the other factors go against you. But in any event, if you do have an agreement, it should define the relationship as a business-to-business relationship. It should set forth, obviously, the services to be performed, including the fee and the term. It should not contain those non-compete clauses that we talked about earlier. And next one, please, Kevin. And a couple of the other factors is that it would be helpful if it set out that the independent contractor is responsible for any income tax obligations, not eligible for unemployment insurance benefits. You know, those are all helpful. But again, if the supervision, direction, and control that's exerted, reserved by the employer is substantial enough, then you know, I don't think that the agreement is going to overcome that. So that's the formal you know, part of the presentation. You know, I would urge all of you to take this issue seriously. You know, from the questions that I've seen coming in, it sounds as if you've given it some thought already, and maybe you've had some experience with it. I expect you have. But you know, there are very significant risks, and you know, it's important to try to get it right. So
I'm sorry. Go ahead, Peter.
no, that's it. Go ahead, Kevin.
I was just gonna. It was like a perfect opportunity to transition to
Sure.
one of the questions from earlier, which is, are there risks for benefits and pensions when, you know, someone, I guess, contracts versus employees? So in other words, and our Fleck, you can correct me if I'm wrong on this, but it sounds like would the company, if found to be contracting when they should be employing, would they also be responsible to pay into benefits and pensions, right? And does that make sense? Is that also an exposure point?
I'm sorry?
Is that also an exposure point if you should have been treating someone as an employee?
I haven't seen that specifically. So I could just say generally that it's certainly a potential risk. You know, whether a company is going to have to pay in, let's say, for a 401k and they match, whether they would have to pay in retroactively, that's an employee benefits issue that I don't know if I can give an answer to that. I haven't worked with that specific issue personally. You know, if it is a concern of yours and you do have those types of benefit plans in your business and you provide them to your employees, then, you know, I suggest that you could ask your administrator of those benefits those questions. But I haven't worked with it, so I can't tell you specifically, other than just to say that it's a possible risk, but I haven't seen it.
Here's the big question I think that most people have in one form or another, and that's given the characteristics of an independent contractor, if someone has all of those characteristics except operating their own business, are they still considered an independent contractor?
I would think so. I mean, when do you, well, I'm not quite sure when you say operating your own business. Does you mean like, you know, incorporating or, you know?
Jacqueline, how about Jacqueline Vincent? Yeah. If you want to just frame this better than I did.
So on this slide number 12, I think the question was just if and obviously knowing these are all very fact specific, but the question on this slide particularly was, if they set or negotiate their own rate of pay, they are paid more than other employees, they set their own schedule, and they're free to refuse work, but they don't meet the last bullet, is operating a business, then would they lean more one way or the other if that last bullet weren't included?
Well, it's, again, I'm not quite sure with operating own business, but I would think that that there's a pretty strong case for independent contractor, a proper independent contractor classification. When you say operate own business, do you mean that they didn't incorporate, or
I'm actually referring to your last bullet, so I don't really know. I'm not.
Okay.
So they fulfill all the requirements except like they don't like tutor on their own.
They don't have their own business card. No, they might tutor on their own, but they don't have their own business cards. They don't have website. They don't have stationery.
Okay, sorry. I finally, I'm looking at the hard copy of this. So.
Oh, sorry. That's okay.
No, that's okay. Yes. I think this is treated the same way that the factors are treated that I went through and later in the presentation. Okay, yeah. Which is to say that if you have all of the other factors that favor an independent contractor classification, the fact that you don't operate your own business in the sense of having your own cards or website or stationery, I don't think that's going to be dispositive.
Okay.
It obviously would help, but I don't see why one wouldn't. I mean, maybe not have a website. But if you are operating independently and you're working for more than one business or person, it would seem likely that you'd have your own business cards or something to indicate that you're operating this business, and it doesn't have to be an incorporated business or any formal structure.
I think a lot of times it's, we're talking about college students, or I mean, they're not, in a lot of situations they wouldn't have anything of that sort, even if they're working for multiple companies, because like you said, gig economy, like they're just like, sure, I'll tutor. So I think it comes up a lot where they wouldn't have any of those things.
Okay, thanks. No, now I understand what you're getting at. So, look, I think you need to consider these characteristics that I laid out here in conjunction with the later slides.
Yeah, I agree.
Right. So, just to use your example of a college student, they might be able to satisfy all of these factors and the characteristics of a true IC. But on the other hand, if they're being told, where to go, what to do, how to achieve the result that's desired, et cetera, and they're under the supervision, direction, and control of the company, I think it's more likely then that they would be an employee.
Yeah, I agree. I think that question was earlier. Once you started laying out the more detailed bullets, that made sense. Right. I actually had one other question. I don't know if New York has this or not, but are you familiar with some of the state tests in Maryland, for example, where they look at if you're doing primarily the same business as the business? Like, I don't know if that's something in New York, but I know in Maryland, that's one of the factors that unemployment insurance looks like. Is that something that comes up in New York?
Well, yeah, I think so. I mean, okay. I think what you're saying is like, if the purported independent contractor is doing serving the same function,
right?
It's kind of like, well, why aren't you an employee? Why are you being hired on this basis? And look, to put it in context, to go back to the earlier part of the discussion about, how revenue generation is a big driver for governments to crack down on classification. They're going to look at that and they say, well, no, this is really an employee, and we should be paid the appropriate payroll taxes.
Yeah, I think California closed that loophole in the same way, Jacqueline. You can't really hire someone and contract them to do what you do as a business. Like, yes. And that sort of like cuts right to the end of it. So it's not even qualitative. It seems, anyways.
Maryland did
I'm
the
not an
same
attorney, and
Well,
I'm not
I
providing
am
legal
an
advice.
attorney, but the Maryland did the same thing actually, and then our state labor director who did that actually became US DOL secretary. So that's where a lot of the worker
That's where we're headed,
misconception
so.
came from.
Oh,
So
is that right?
It sounds like if
unemployment's gonna
you,
drop, right? I guess across the country.
Yeah.
So Rosemarie Janice has a question, which I think you answered already. Can owners issue a non-compete with an independent contractor? And you said that was kind of a no-no because that means that exerts control. However, what about a non-disclosure? So a non-disclosure agreement.
Oh, I think that's more appropriate. Non-disclosure of a confidentiality agreement, an NDA. Yeah, I don't think there's anything that's inconsistent with the independent contractor relationship or model with those types of agreements. You know, it's when you're telling them they can't work for you can't go across the street and work for your competitor, but still you're an independent contractor. That doesn't all add up.
Right. And even if you're an employee, I mean, I fought these in court back in the day for Kaplan. We just lost. You know, it's just
Right.
not. It wasn't an easy thing to prove. Even though we trained and gave the curriculum to the tutors. So interesting. How about does it matter if the tutor communicates with the client using a company email address versus a personal email address? So is there?
Well, if the tutor is given a company email address, you know, I would argue that that's an indicator that the tutor is an employee. Yeah, so I think that that's problematic.
Okay.
it sounds like overall that given the supervision and control aspects, that unless there's fairly particular circumstances, for the most part, if you're running a tutoring company, you're better off with W-2s than 1099s. That is the safer path. Is that a fair summary?
Well, I think it's safer, yeah, because you avoid those risks that we talked about for sure. And you know, I don't know how much variation there is within your industry in terms of how you treat tutors, but based on the case law that I read, it seems to me that there's that it's kind of uniform, that the model is roughly the same, and I will tell you this, that I didn't come across any case. Well, I came across one case, that was it, where the court found that there was an independent contractor relationship. But those facts were pretty unique because it was a company that was actually had contracted with the Board of Education in New York. And there were certain very specific requirements that the company had to meet under that contract. It was a government contract. So the point is that in all the other cases that I read, there was a finding that these individuals were employees. And so I think you're right, Neil, that probably the safer way to go. But I'm not going to tell the group like definitely do that, because there might be different facts that apply, and there probably are reasons why one might want to have an independent contractor. There obviously are reasons for it.
A good question was, do you know of any insurance that a tutoring firm can obtain to protect against professional claims like this?
Well, yes. First, let me say, here's my disclaimer. I'm not an insurance lawyer. I'm not an insurance broker, but I have some knowledge about insurance as being a lawyer. So I would recommend that you speak with your broker, but subject to that, I think that, there is in EPLI, Employment Practices Liability Insurance. That's one thing you might want to look into, so that in the event there is a claim brought against the company for improper employment practices, there can be coverage for costs of defense as well as liability costs if there's an adverse judgment or finding. So that would really be the type of insurance that would apply in the employment area. There's errors and omissions, and there's directors and officers liability insurance, but I don't think that that's what we're talking about. I think we're probably talking about EPLI.
Got it. Okay. That was super helpful. Thank you. Does it matter how many hours?
And let me just, Ted, sorry to interrupt. Let me just say that I would actually urge you, just as kind of a general advice, urge you to speak with your brokers about, insurance brokers about EPLI coverage, because these lawsuits can be incredibly expensive to defend, let alone if there's an adverse judgment rendered against the business. And the insurance, depending on the size of the business and other underwriting factors, the insurance might certainly be well worth the cost. So it's certainly worth looking into. I've had clients who have insurance, and I've had clients who don't have insurance. And the ones who don't have insurance tend to wish they had it once there's a claim started against them.
That's good advice. How about, let's see, does it matter about the number of hours? If the tutor is classified as an independent contractor, does it matter if they work 10 versus 20 versus 35 or 40?
I think it's a relevant fact. Sorry?
Each week? Yeah, sorry, I didn't qualify it.
Yeah, I think it's a relevant factor. Look, if somebody's essentially working full-time for you, working 40 or more hours or 35 hours, it just seems to lean very strongly in the direction of there being an employment relationship. If somebody's putting in, all right, well, I'm working for company X for 5 or 10 hours a week, and then I've got a couple of other gigs, and I'm working for other companies for a few hours a week. All told, I'm working 40 hours, but for 5 different companies. And if the business has those types of relationships, it's more likely, or I think easier for them to argue that it's an independent contractor.
Great. I have a question. And you may have covered this, but what specific paperwork does one have for an independent contractor in contrast to what one has for an employee? So like the human resource file, the employee file, can you contrast those?
Sure.
Thanks.
Sure. Well, independent contractor, you really don't need any paperwork. I mean, with a couple of footnotes, which I can give you, at least local footnotes. So in New York City, there's a local law called Freelance Isn't Free, the Freelance Isn't Free Act, and it was intended to protect independent contractors who were getting stiffed by their contracting partners. And there's a requirement that there be a written contract and some other requirements. But I'm not going to get into all that right now. But that's in New York City, so it's somewhat limited applicability, I think, to this group. And so that's on the independent contractor side. And so if your jurisdiction doesn't have something like that, the only documents that are necessary would be tax-related documents. Getting a W-9 from the independent contractor, and then issuing a 1099 to the independent contractor. There might be other tax-related documents that your accountant would be better suited to respond to, but that's my understanding. In contrast with an employee, again, depending on your jurisdiction, but at a minimum, there's an I-9, which is an immigration form, so the person has to, show that they are eligible to work in the United States. There are tax-related forms that are different than the tax forms that are issued to independent contractors. In New York, there are certain wage notices that need to be given, and my guess is I can't get into California because there are very specific and detailed employment laws in California, and very employee, they favor employees strongly. So there might be some similar types of requirements in California, but I know in New York, there are certain notices that need to be given. In New York, there's training that needs to be given, anti-sexual harassment training, but you asked about documents. So, on the document side, yes, there are definitely documents that need to be given to employees that are not required to be given to independent contractors.
Excellent. I see the note from Cleo. Yeah, I feel like Cleo, the sort of the movement is, and it happened like 10 years ago too, but the movement is, again, to employ your tutors to avoid sort of these major exposure points that Peter was talking about at the top of things.
Can I, just one thing, because I'm following this discussion in the chat.
Yeah.
And I think it's an interesting, I just like to hear Peter's thought on it, because so with what you said, I mean, tutors being classified as employees, but then if there are tutors out there who want to be ICs because they prefer to be, in control, I think who wrote that? Chris wrote that. I guess you either, sorry, we're only going to hire you if you're a W-2. I mean, there's tension there, right? Because if the individual wants to be classified as an IC, I know that the law says like you can't, just because you want to doesn't mean you can. But I think with such a gray area in this, you come across that too, of how do you deal with that when you say, okay, we believe legally from a liability standpoint, we need to classify everyone as W-2 employees. And then some of your tutors say, absolutely not. I want to be an independent contractor.
Mm-hmm. Well, there is a tension. You're right. And that's really it's a business dilemma. It's a business decision. Yeah. If you determine on your own or through consultation with your attorney that really your model is going to be an employer-employee model, mm-hmm. and you're not going to hire independent contractors, well, then yeah, you might lose a few prospective tutors. Yeah. There's nothing you can do about that, right, if that person is dug in. And I'm aware of that. I know there are plenty of people, in a variety of industries. I mean, they don't want to be employees. They want to be independent contractors. They want to treat their taxes, however they treat them as, being in their own business. And it's not to say that it may not pass muster. It might, but it's risky.
Yeah,
it is risky, and interesting. Does anyone operate a business that's essentially just matching? So just matching tutors and students, not telling the tutors how to tutor, not providing them with books or material.
We had this at Noodle Pros. In fact, tutors who got most of their work from us and served a sufficient number of hours, W-2s, but those who were just on our website and got clients either through the website, but also got their own independent clients were independent contractors. So we actually had this kind of funky hybrid model.
Interesting. Yeah, we have for tutoring generally, it's just matching. There's not really anything, but for example, we also do SAT and ACT prep, and then there is a curriculum that we would do. So that would be kind of a hybrid.
Yeah, we didn't have a standard curriculum. And so tutors set their own rates. And so we acted in many ways more like independent contractors. But once they went high volume and got a lot of work through us, they got benefits and they got, in some cases, equity. And then in that case, we treated them like employees.
That's interesting, because I have to double check, but I saw a case recently involving TaskRabbit. It's a New York decision, and in that case, if I recall correctly, the court found that they were independent contractors because it really was just a kind of a matching service. There was no supervision, no control. They just put A and B together for the particular job.
I feel like that's what Varsity Tutors did when they launched too, and I may be wrong about that. From Chris. Is your organization at greater risk if you have that hybrid model where you have some ICs and some employees?
I'm sorry, I was distracted for 1 second.
So
There was a call
the
coming in on
question
this.
is like, if you have some people in your organization that are IC, basically what Neil just said, if you have some people that are ICs and also some people that are employees performing roughly the same tasks, is your organization more at risk?
I think so. I think so. I think that, if you have, people, two classifications doing the same, performing the same function, how do you going to justify that? And what factors what factors can you point to that the independent contractors have to support that classification? I mean, how do they differ?
Anyone from the tutoring side of things that wants to talk about one model or the other, like what's preferred?
I'm a tutor for a company that has me as an employee, and then I'm an IC as well. And I would say that I prefer being an independent contractor. I get paid much more.
Gotcha. And Christy, and I know you, and so I know you're a math person. Have you
Right.
done the calculations for, I guess, what you're losing out on in terms of the employee side of things with benefit, workers' comp, the things that you would have to pay independently as a contractor on your own? Have you done the math to square it to see if it's, one is better than the other?
Not yet, because it's fairly new to me being an employee. I only started back in October, but I'm sure eventually I'm going to be calculating that to figure out those figures. But as it stands right now, I prefer being an IC. Definitely.
Gotcha. Thanks.
Yeah, that's interesting. So can I ask you without prying, when you said you make more, you earn more as an IC, is your rate higher as an IC than it would be as an employee?
Correct. It's about twice as much.
Oh, wow.
I make twice as much hourly as an independent contractor than as an employee.
But you're not sure how it all nets out yet.
Yeah, like I get some great benefits part-time as an instructor at the place that I'm an employee. They give me paid sick time. They give me a 401k and some other benefits. But in the end, I think I'd prefer just being paid more.
Right.
Twice as much, that is.
Sure.
But I understand the business is going to have to do the same calculation as to how much more it's going to cost them to pay all the workers' comp and all of that. And so they can't offer you a higher rate.
Exactly. So I understand it completely where they're coming from. But it's a great company and I love their mission. So that's why I'm with them and I stay. But the bottom line is, yes, I prefer being an independent contractor.
Yeah, the rule of thumb, if you want a rule of thumb to calculate what a payroll dollar costs you when you employ someone, it's usually like 1.18 to 1.24 per payroll dollar. So if you pay a payroll dollar, it's like $1.18 to $1.24 when you're also picking up benefits and workers' comp and 401ks and all that stuff. It varies by state, but if you just need a back of the envelope reference, that'll help. Peter, do you have guidance at all about how to arrive at a decision to move from employee to an IC model or an IC model to an employee model?
How to do it or whether to do it?
How to. Like what are things you should ask yourself if you're thinking about moving your model from one to the other?
Well, I think, first of all, you'd want to determine whether you think the classification that you want to move to will be proper and legal. So, I think that's an easier question to answer if you're going from an IC to a employment model. Obviously there's less risk, and based on some of the case law I've seen, it seems to be that it's more likely that it would be the correct classification. So if you make that decision that that's the direction you want to move, then it's just you have to set up payroll, and you need to make sure that you're complying with all of the federal, state, and local employment law requirements regarding onboarding and whatever notices need to be provided. Both, right? And there's a lot, but basically you're creating, you're now treating them as employees, and you've got a workforce, and you've got to make sure they're paid properly with the correct withholdings and so on.
Got it. So, so we're a little over time actually, and unless there's any more questions, I think we'll wrap it here. Peter, I want to thank you so much.